You're listening to Legacy Lawyers, hosted by Michael Haslam and Nathan Croxford.
Hi, everyone. Welcome to our podcast. We're excited to have you join us today. My name is Mike Haslam. I'm one of your hosts, and I am joined by Brian Edwards. Hey, Brian.
Hello. What do you consider me now? Just a guest host every now and then, or a expert every now and then that comes in? I don't know.
Yeah, I'm going to call you co-host, Brian Edwards.
I'll take it.
I
like it. It sounds really official. I like it.
I mean, if you do something once or twice, right, you're just a guest. But is this your third appearance or fourth?
I think this is my fourth.
Yeah. So, I'm joined by my co-host, Brian Edwards.
That's right.
It's a new year. That means things change.
That's right, yes. Happy 2026.
Happy 2026. Looks like you're doing well. You've already started all your resolutions off with perfectly.
I'm doing good still, actually. Yeah. I still have to remind myself what some of them are, but on some of them that I remember, they're good. So,
I don't know if I actually asked you. Do you feel comfortable sharing one with our audience, Brian, or are they pretty?
I'm happy to share one. I don't mind one bit. I think it's like what a lot of people have. Just get more fit, have more energy in life, and
yeah,
and so I decided we're just gonna work out more. And I mean, yes, we're 1 week into the year, but I've done it twice now this week, isn't it? That's my goal right now. Is like just do what you can. It's something more than I did before, so
it adds up. Something is more than nothing.
That's right.
I like it.
So it's good.
I'm workshopping mine still. So my 2026 goal is to have my 2026 goals by the end of January of 2026.
There we go. That's a good one. So I like it. We'll report next time then, I guess.
Yeah.
Where they are. So
just nothing is spoken to me yet. So I don't like to make a goal just to make a goal. So I gotta find something.
That's fair. That's fair. I like
it. What we're gonna talk about today, what changed, was the Utah Health Care Directive law, or sometimes people call it like a healthcare power of attorney, or it's also referred to sometime as a living will, which is super confusing because a living will, people think last will and testament, not the same thing. A living will is usually the pull the plug scenario, right? Mm-hmm. So all those things are referred to: living will, healthcare directive, healthcare power of attorney. They're all codified in Utah under the same section, and they're really one and the same document now. And our legislature redid it all.
They did, yeah. There's some changes. I don't think it's overly drastic. I mean, because we had something in place that worked well, and I think it was good. There are some changes that we noticed as we went through it that we just want to highlight today. But again, I think there's just some slight changes. The form change, which is the big one, right? And we're going to talk about that. But just reading through it, it's. I mean, if I'm listening to this, I'm like, wait, I already have one, and you're saying that there's changes. I don't think it's. Yeah, if you want to come in and talk about it, we can talk about, should we update it or not. But I don't. I think what was in place is still a good system. This is just kind of tweaking it slightly to make it even a better system.
Yeah, they updated it or modernized it, basically.
Yeah.
So just to be clear, if you already have a healthcare directive or healthcare power of attorney, it's still valid, right?
Correct.
If you haven't looked at it in a while, this is probably a good cue to revisit it. Would you agree?
I would agree. Yeah, for sure. No time like now to do that.
So there was 2 or 3 things they did completely different, though, that we haven't really had in the code section, which I think we both agree we like. And then what Utah and almost all states have done is they've came up with kind of like a standardized form for their healthcare directives. And the idea behind that is when you show up to a hospital and it's urgent, and you give the doctor or the medical provider this healthcare directive, if they have to send it to legal and wait for 3 to 4 days for legal to review it and come back to the doctor and say, hey, this is what this power of attorney says, this medical power of attorney says, like, there's could have been hundreds of medical decisions that had to be made in those 3 to 4 days. So we've attempted to give our medical professionals a document that looks the same as much as possible so they can quickly determine what their patient's wishes are and what the scope of their authority is. So we're changing that. The form's going to change.
Yeah. Yeah, and do we want to start with the form? Do you want to go there first?
Yeah, let's start with the form. What did they change about the form?
Well, first off, I mean, this was the same with the other form, and just straight out of the statute. This form is in the statute itself, like it's in the law. The way that's formatted and the questions that are asked, it does say it's an optional form. So I mean, if somebody really wants to go out there and create their own, you're still welcome to do so. But yeah, if the state's going to provide a form, it's best just to use what they have, because then what you just said, it's standardized and whatnot. Going on to the form itself, we have a copy of it here in front of us.
Should we share our screen for those who are watching us on video? I can share mine.
Yeah, let's do that. And as this goes on, I mean, the old form was 5 to 6 pages. This one, same thing, about 5 to 6 pages. So it's not really a lot of new information. There's some new information. But like, they reword it just a way and they ask the questions a little bit differently. But yeah, we'll just go through it. One thing that doesn't change right here on the beginning, obviously, is, well, we need your information, and you get to list an agent. Who is going to act on your behalf if you cannot make these decisions? So that's on the first page. On the second page right there at the top is an alternate agent. That hasn't changed either. If you still want to list a second person or even more, I'm sure you can still list as many as you want. This form only gives 2, but there's no reason why you can't list more. So really where we start getting into changes is right where Mike's at. This is part B. Now we're going to list our healthcare instructions. Instructions just right
So
here
it
on
jumps-
number 1.
Oh, sorry, Brian. Yeah, the format's different because it jumps right to life-sustaining treatment, where before the old form had that at the end.
Yeah. Right at the get-go, the very first question is, well, let's read the instructions first, right? This section gives you the opportunity to say how you want your agent to act while making decisions for you. You may mark or initial each choice. You may also leave any choice blank. I think they add that just to make you know that, this is all optional. Nothing on here is, you must fill out this out form, right? It's all optional. So
And then
it makes it a little bit difficult for your agent to decide at that point, I think, but you can leave anything blank that you want to.
yeah, and then they start with treatment first, right? Like medical treatment. So when should they provide medical treatment versus just let you pass away, right?
Yeah.
So keep me alive is the term they use. Keep me alive, but not needed for comfort.
Yeah.
And what do you think of these 5 choices? Do you like how that's broken it out a lot more? The old one just said, I've told my agent, just listen to them. It was very, very, very open-ended.
Yeah. This one makes it feel like you have to give a choice. Maybe there is an other where you can still write something like that in, as like, I've talked to my agent rather than let them decide. But here, it's just kind of giving you more of the choice. Always give it to me, which was in the old one. We had that option of keep me alive as long as possible. I think that's what's saying there. But then the next 3 options are not to be given to me if this condition occurs. The first one, if the condition is curable, expected to cause my death soon, then don't give it to me. If you're unconscious and unlikely to retain your consciousness.
Yeah.
Or the third one.
So,
go
yeah,
ahead.
I mean, we can read them all, but I think just to kind of make it easier for our listeners, like, either you can list out the scenarios you would want them to not provide medical treatment, and you can initial those. Us as a firm, we haven't beat this up yet and say, hey, do we like this language? Is this practical? But I mean, the thing I would probably point out is the last one is other. Write what you want or
Yeah.
don't want.
Yeah.
And I think this is where we will probably slip in. Like, I've had a detailed conversation with my agent. They know, just listen to my agent. That's my initial thoughts. What do you think of that, Brian?
I was thinking that too. Yeah, that's where we could put that in there. And it's here under this first one again is about treatment. The second one is called food and liquids. The third one is pain
And
relief.
that's new, right? The food and liquid, we didn't have anything in the old directive
No.
that talked about that.
Not at all. Uh-uh.
And that would get a little tricky because some people feel really bad, like watching their loved one not eat or not drink, and be like, shouldn't we be doing something there? And
Yeah.
sometimes they didn't talk about it. So I think I like that they put a section in if people want to. Again, they don't have to initial anything, but they can.
Yeah, and once again, it has other. So if we need to write
Yeah.
something in there, we can on
Yeah.
that one.
And then the next section is pain and relief.
Just again saying, yeah, if you're in significant pain, do you want to remain comfortable, even though it's likely to shorten your life? Do you want to remain comfortable till the end of your life? And again, still has the same questions on situations where you can write. You can also write in other instructions. So all three of these questions, if they feel new, at least they're drafted differently, and it's asked a different way on how you want to, how you want to answer these questions. But that's in here. And I kind of like how they just start off with that. To be honest, here's the first thing that we're going to do is talk about these.
So yeah, I like how they left other in all these categories. I like how they broke it out more, because a lot of our clients have that conversation with us, and they're like, "How does my agent know?" And we're like, "Well, you need to talk to him," or we can write something and put it in your plan for them to read later on.
Yeah.
But no one really wants to take the effort to do that, and then so this has made it pretty easy. They can just check the ones they agree with and kind of have much more guidance for their agent.
Yeah.
Okay, then the form switches to the priorities, right?
Mm-hmm.
And this seems to be about kind of helping the agent know what is most important to the person who filled out the form, or our client if we're the ones helping them fill it out.
Yeah. First two, and all the answers are: is this very important to me? Is it somewhat important to me? Or is it not important to me? Just saying, it's really just kind of your preference. What
So
are
let's
your
pull-
priorities?
Yeah, let's pull 2 or 3 of these out as examples and just talk. Yeah, kind of maybe say why that would be helpful if people knew that priority.
Well, the first two go hand in hand. Staying alive as long as possible. Do you want to stay alive as long as possible? Either because of even if you have a substantial physical limitation or mental limitation, how important is that to you to stay alive, or is it pull the plug, as we say a lot of time? Like, we'd rather just do that. So you get to say, this is important to me, or this is not so important to me.
I think being independent is kind of interesting.
Mm-hmm.
Like, how important is it to me to be independent? Like, why? Like, I mean, I don't know if anyone marks it's not very important. I don't know if anyone's going to say it's not really important to me. And I'm just trying to think, if I'm a healthcare agent, right, and I know that the person I'm helping, it's really important for them to be independent. I guess that could maybe change some of my decisions.
Maybe yeah, I can see that. So
I don't. Yeah, but I mean, I think the medical condition just dictates that no matter what, right? Like, yeah, I know I know you want to be independent, but you can't. You can't do these 5 things by yourself anymore because your health. So
yeah,
like, that one to me feels weird. But most of the other ones seem to make sense. Are there any others that seem to?
I like one on here: having my agent talk to my family before making decisions about my care. A lot of times, I get a lot of clients who we list one child as the agent, And then they tell me, no, but they can't. They need to talk to everybody first before anything is made clear or anything is decided. And so I always tell them, well, that's possible. They can talk to whoever they want to before they make a decision. There's nothing wrong with that. But here, it's asking it, saying, is that important to you to make sure that all family members are involved? Like, do you want them to talk to all family members before a decision's made? For some people, that may not be important. I can think of a handful of clients where they don't want family members involved. But again, I think it's a place where they can mark, hey, make sure you talk to everybody before something is decided about my care. So I like that one. The next one's about friends too, and which goes hand in hand. But I think the family one is the kicker on that one.
So anytime I read a contract, especially like a document that's going to give instructions to someone else to do, I always like, well, what if I get a call from a client that says, hey, the healthcare directive says my brother's supposed to tell me about, what's going on before they make any decisions for my mom or dad, but they've cut me out of the loop. We don't talk, we're not on good speaking terms, whatever it is, they're cutting me out. Well, then what, right? Like, did this really help, and what can be done about that? And so that will be interesting to see how often we get that now, because that was not in the last directive. Now, the statute had some things about the agent had a duty to keep people reasonably informed, and there was the previous statute but now it's in this form, and I think we might be seeing those calls a little more often, like they didn't keep me in the loop.
Yeah. It's good to know. Good to mention. This part C here, optional special powers and guidance. A lot of these questions were in the old form as well. Can we be admitted to a facility? Can we get access to healthcare information? That was in the other form as well. So I think it's just asking it again.
Well, so what's kind of different is this mental health treatment.
Mm-hmm.
So that was not in the old form, and the last statute didn't address mental health very well. So my agent can do the following things only if I marked or initialed them below. Admit me as a voluntary patient to a facility for mental health treatment for up to 14 days, whatever they write in. If I do not mark or initial this choice, my agent may not admit me as a voluntary patient. That one is really interesting to me because we've done a lot of parents that have children that turn 18 that have significant mental health challenges. They're like, what do I, is there anything I can get in place to help take care of my kid when their mental health becomes to the point they need, to be admitted, or they need extra care? Like, what can we have in place? And before, we'd have to do kind of custom language to try to address that, or get limited guardianships for them. We've done that a few times. A guardianship that's just limited to scope for help medical, and so I like that in there.
Yeah, that's good.
And then we have access to health information. That's pretty straightforward. And then this was one me and you talked about. What's your thoughts on that, Brian?
So it's asking how flexible do you want your agents to be in carrying forward your wishes in this document? And the question what you can answer is, I give my agent permission to be flexible in applying these instructions if my agent thinks it be in my best interest based on what my agent knows about me. So technically, if that's marked, an agent can probably go off of your instructions slightly or a lot if they think that is in your best interest to do so. If you don't mark this, the document says that they have to follow exactly the agent must follow the instructions even if your agent thinks something else is better for you. So it gives you the choice on how flexible you want your agent to be in carrying forward your instructions here. I think that's a good thing. It may go back to to the part where we talked about, I've talked to my agent in the last form where it says we talked to the agent. They know my wishes. They know what I want. So it kind of alludes to that slightly. It's worded obviously a lot different from that, but it's still allowing them to have flexibility and being able to apply what you've decided. And again, you have the choice. If you don't select that, then they're just limited to exactly what you have on the form here, and can't deviate much.
And I think some people who check it, we're going to see a few family members misunderstand that as like, I can do whatever I want.
Yeah.
And I think the key thing for everyone to remember is this best interest language, right?
Yeah.
It's fine if you deviate, but you have to still have some justification why it was in their best interest. Yeah.
Yeah.
So that'll be interesting to see how that one impacts things. And then number 4 is you can nominate a guardian. That one's pretty standard. You can donate organs. That's in there. You can clarify.
Cool.
Oh, go ahead.
Oh, sorry. This organ donation on that second page, the purpose of the donation, you can mark where you want your organs to go. Where are we donating organs for? To transplant, therapy, research, education. That wasn't on the last form. It was just, hey, do you want to donate your organs? So here it says, well, what do you want to donate them for? If you mark yes, I think that's kind of cool that they've brought that out. I didn't, to be honest. I guess I mentally thought that there's other reasons, but I always thought like when you're donating an organ, it's for transplant only. But here you go. Here's some other reasons you can do it.
Yeah. Yeah. Well, and like I think this is a little broader. So sometimes people actually donate, the whole body to education and research sometimes. Yeah. So I think this allows like just a organ too. So that's kind of cool.
Yeah.
One other thing that kind of jumped out to me, and I was going to go double check, it just didn't ring a bell with me, is, it says, hey, this needs one witness. It needs to be an adult. It can't be the person who's going to be the agent. It can't be the agent's spouse or someone the agent lives with as a couple. So that last one, I don't remember I don't remember that in the last version. So I was going to double check that. But basically, if you're not married, but you have a significant other, they can't be a witness on it either.
Yeah, I don't remember either.
But
I'd have to go look at it. But.
And then if you're living or receiving care in a nursing home, the witness cannot be an employee or contractor of the home or someone who owns or runs the home. So that's kind of interesting too. So you can't, if you're in the only nursing home. And then I was going to look a little closer at the statute to see if that nursing home statute's going to apply to assisted livings. So,
yeah.
And that's the new form.
Yeah.
So overall, 1 to 10, what would you rate it, Brian?
I like it. I'd give it 8, 9, somewhere in there. I do like it. I think it's good. It's a missing couple parts probably, but overall, I like how they reworded it and brought out those specific questions a little bit more to help somebody really think through, like, what are we talking about when we talk about life-sustaining care and things like that. So I do like it.
I think it's definitely an improvement. So, and then the law itself, I mean, the form addressed a lot of the changes. I think that's why it made sense to kind of just walk through the form. Mm-hmm. But the law itself, there's one thing that was not showing up in the form that's a pretty big change. This concept of a surrogate. How would you kind of describe that?
Surrogate, yeah, the surrogate is who will be the person that's making healthcare decisions on your behalf if you don't have the form in place, is kind of where the statute leads to. So if you don't have this form in place, let's look at statute and see who will be your surrogate, who will be able to make these healthcare decisions on your behalf.
So what do we mean by maybe what's the definition of a surrogate? Does the statute? Let's maybe read it.
It does list it. I did see it. Let me see.
The way I think of it, surrogate's just a person that's authorized to make medical decisions for you when there's no agent available.
Yeah, an agent, a default surrogate, or a guardian authorized to make healthcare decisions.
Okay.
Is what the statute says.
That's close.
Yeah.
So this would probably be a situation where they just didn't do the healthcare directive, or is this more like they don't have any family, or
I think both. It goes through a list of, again, so if you don't, it says if you don't have one, but again, like if you don't have family or you just, or whatever, like it does have a list of people in order of like, well, this is who we'll look for
priorities?
next. Yeah, priority list of who will be your agent. And I mean, it's pretty, I'm not gonna say common sense, but logical in the order of like who it will be, like somebody that you name first. If not, then your spouse, as long as you're married to them. There's a couple other nuances with that, but I won't get into that right now. But a spouse, adult child or adult parents, a cohabitant, an adult sibling, and it just kind of goes down, kind of extending from there. It stays within the family mostly, but if you don't have a family member, then it will allow for people outside of your family. So somebody who's been assisting you for over 6 months in the preceding 6 months, stepchildren, if there are any of those.
As cohabitant, right? An individual's cohabitant is in here.
That's in there too. That's even above an adult sibling. So before your siblings come in, if you're living with somebody, that cohabitant can make decisions for you first. So, yeah,
Grandchild or grandparent. So you just kind of it kind of starts who's closest to you, and then starts working its way out.
yeah, and that's what I mean. Like it's pretty reasonable is not the word I want to use. It makes sense, I guess, in the order that they listed. In that regard, is like, yeah, let's keep it close and spread out from there.
So this one's interesting to me. So like you get through, there's no family, and then it just says an adult who has assisted the individual with support decisions during the preceding 6 months. So
Making routinely.
Yeah, that's going to be interesting a little bit. The healthcare providers will have to decide if they're going to accept those people as surrogates. I think that's just going to fall on them to make their best judgments. So the doctor or the hospital.
Yeah.
They're like, have you been helping them for 6 months? And so, yes.
But I mean, even going down further, you have stepchild next, and then it's it looks like it's an adult not listed in any of the above who has exhibited special care and concern for the individual, and is familiar with their personal
Good
values.
Samaritan.
Yeah,
Good
just kind of browsing
Samaritan.
further. I guess that could be, I collapse on the sidewalk and then some stranger finds me, right, and takes me to the hospital.
I could see that being like a lot of like religious leaders.
I see. That makes sense. So,
And then last but not least, doctors, physicians.
yeah, and even they have certain requirements.
They have extra rules, right?
Yeah.
Because there's some inherent conflict of interest for them as a
Exactly.
medical provider.
Yeah, and that's listed out here in the statute.
Yeah.
As what they are.
We'll save that for another day to go through all the.
That works. I like
If you're a
that.
doctor, can you be a surrogate?
That's
That could be a
right.
whole episode.
That's right.
So I want to go back though, Brian, because the first category after spouse are the individual's adult child, right?
Yeah.
So I got 4 kids. 2 of them want me to get the surgery. 2 of them want me not to get the surgery. I'm unconscious. I never did a healthcare directive. So they're going to the surrogate statute.
And that's where we land.
And my kids are deadlocked. Is that a problem?
Oh, for sure. Yeah. And that's seeing that. I mean, I saw it's the same level as an adult parent as well. I'm like, well, what if my adult child and my adult parents, they're at the same level? Like, what if one of them wants one and one wants the other? So it's the same thing, but
It says
Yeah.
or.
yeah, if there's a conflict there, it's I don't know how they're going to decide that or go from there.
It's court. Yeah, you have to go. Yeah, you're gonna have to go to court and have a judge appoint a guardian. At that point, you're just gonna be petitioning to become the guardian.
And while that's happening, while that's waiting, because that's not going to happen overnight. Maybe it could, I guess, but probably won't.
Try to do an emergency one and get it in a couple nights, but it's definitely
Yeah.
not the same day thing or next day thing. Usually,
Yeah.
sometimes even the emergencies can go a week or 2, right?
Right.
So you can't. So the surrogate thing, I like it, but the reason I point that out is you can't just have this false sense of I'm covered. My kids can just make that decision, or my parents, or even my spouse. Oh, my spouse will just decide it. Because what if you and your spouse are in the same car wreck and your spouse can't give your medical decisions? And then they go to your 2 kids, and your 2 kids disagree, and then they're going to be in court.
Yeah, situation that we can avoid, a situation we want to avoid.
Yeah, and the healthcare directive is just so easy to do. It's nice if you can do it with your attorney when you're doing the rest of your estate planning, because they can help you like tie it into the rest of your planning better and help you understand some of the choices you're making in the document. But anyone can go to the Department of Health's website, print off this form we were showing, fill it out, get your neighbor to witness it, and that is just the bare minimum. Every adult over 18 should do that. Period. No questions asked. If you're listening to this podcast and you have not done a healthcare directive, you got to do it.
And I'm just curious, Mike, just your opinion. I usually tell people on that agent to go 2 to 3 people deep. I don't know. What's your opinion on how many people should be listed as an agent or alternate agent?
Yeah, like 2's like the bare minimum, right? 3's ideal. I haven't seen people go past 3 yet. I'm sure one day something weird. And a lot of people think, that they're not all going to die, and that's not what usually happens. It's a voluntary job. Like, people can quit. People can have health issues of their own, so they can't be the agent. Like, there's a lot of things that cause your first choice not to be able to do the healthcare agent responsibilities. And at least a primary and a backup, but three's better.
Okay. Yeah, that's
but the form only allowed a space for 2, and so that's why the healthcare directive we'll be filling out with our clients. We'll be taking that form and adjusting it and adding things that we will we'll have an improved version that we use. So
That's right. Like it. Good.
Well, that was good. I'm glad we got that out of the way at the start of the year. The new healthcare. If you didn't do a New Year resolution like me and you couldn't come up with one, now just do that. I gave you one. Do an updated healthcare directive.
There you go. Yeah, I like it.
It's an easy win. You can feel good. You got
Check
got something important done. Yeah.
That's right. That's good. So, okay. Great.
Thanks, everyone. We'll catch you next time.
Bye.
You've been listening to Legacy Lawyers with Michael Haslam and Nathan Croxford. We give you the juicy detail of cases that our law firm has dealt with. We take out the lawyer talk and legalese and show you what options some of our clients had to choose from to fix their situation. The effects of not doing planning can be devastating. We'll be back soon, but in the meantime, hook up with us on Facebook and Instagram at Voyant Legal. Call us at 801-951-0500 or send us an email at team@voyantlegal.com. And for commonly asked questions, hit voyantlegal.com/resources. We'll see you next time.